What's going on, everybody? Oh, good Sunday afternoon. How you guys doing? Come on in here. Y'all, we have some documents to go over. How y'all doing? Happy Sunday afternoon. How y'all doing? Oh man. I want to say thank you all so much for the support. As you come in, hit that like button. I appreciate all of you all. I will be going live on my second channel. Dr. Nini has the Muppet version of Malware video. I have seen it and it is absolutely hilarious. So if you guys can, make sure you are subscribed to the Lady Luck Club with Sweet Tea, because over there, we have fun. That's where I get my messiest. Oh, I'm going in on Malware. Oh my goodness. While she's trying to give dating advice on a dating app. Also talking about, I don't have anybody. Oh no. Oh no. She should stay away from, the internet for 8 months. Girl, I'm about to go in on you. So y'all make sure y'all subscribe over there, because we're gonna have a good time today. Shout out to Dr. Needy for sending me that video. So in the meantime, I'm not gonna keep you all too long. We're gonna go over these documents. This is the FBI plea deal for Keith Freeman. Now, just in case you all forgot who he is, or you don't know who he is, I'm just gonna play one video to jog everybody's memory, because I just want people to understand the severity of the situation with Tiffany Henyard. So let's see here. I've done a video on them in the past, but I want to just get something real quick. Oh Lord. Let's go to Nate the lawyer. He does a great job. He does a great job. Hold on a second. All right. What's going on, y'all? We're going to pull up Nate the lawyer so you guys can, for those who don't know about Keith Freeman or even Tiffany Henyard, we're going to have a great reminder with Nate the lawyer. Shout out to Nate the lawyer. Hope you're doing well. You guys keep him in your prayers as always. He successfully had surgery done to have a removal of a tumor, I believe, on his brain, and he did post it up on his page. And I sent the comments over. I hope he saw them. And he's a fantastic attorney who also has a great YouTube channel, and so I hope he is still doing well and recovering. And he has covered this as well. So this video was from 2 months ago, where he spoke on the update with the police chief and with the hood rat Keith Freeman. So we'll see both of the people that have taken plea deals with the FBI in this video, even though I have 2 separate lives to cover the documents, the actual plea deal itself. Reason being is because I know it's boring to go over court documents. That can be very boring. The Lady Luck Club, have the greatest way of making it fun and interesting, but I still want to break it up so that these can still be 2 separate videos, so that you guys can understand the nuances in those plea deals and their charges and the court documents that we're going to be going over, because all of the charges they have aren't the same. All right. Plus, it keeps down the videos to a nice, hopefully less than an hour. So let's get to it. Shout out to Nate the lawyer. Let me know when y'all can see it here. Hit the 4. Let's get to it, and then we'll get some comments after that. Y'all hit that like button coming in. Let's go.
My name is Tiffany Henyard. I am seeking $100,000 for 10% equity in my business, Tiffany's Good Burger and Soul Food.
A guilty plea and cooperation from a top ally of former South Suburban politician Tiffany Henyard. WGN Investigates has learned former Dalton Police Chief Lacy is pleading guilty in a personal bankruptcy case. His plea deal includes the promise of cooperation with unspecified current and future federal investigations.
Okay, so we have our first Tiffany Henyard update in a while. Let's talk about it. So we got a report from Dalton again, where the former police chief Ed Lacy is now pleaded guilty and has turned state's evidence against Tiffany Henyard. Now, if you remember, maybe about a couple of years ago, the former police chief was fired and then he was indicted on bankruptcy fraud.
We have some breaking news coming in from the south suburbs right now. The acting police chief of Dalton has been charged with bankruptcy fraud. Louis Lacy is accused of filing misleading statements in his 2019 bankruptcy case. Lacy is a close ally of Dalton Mayor Tiffany Henyard.
Now, Chief Lacy is an interesting character, to say the least. I'm gonna let my boy Tommy G tell you a little bit about Chief Lacy.
The man you see here is Deputy Chief Lacy. While you might look at him and think he's a Walmart version of Detroit urban survival, he actually is a man with a disciplinary report thicker than the Bible. He currently has 3 active lawsuits against him. All 3 of them alleged violations of the Constitution for the acts he is committing. Let me share some of his past actions with you so you can get a picture of the man he is. Let's start with his petty incidents. One of his reports details him threatening the water company over a $300 bill he didn't want to pay. He's also known for trying not to pay tolls when he drives through them. But things get more serious. Many residents have banded together to note his excessive use of force and his use of the taser. In a 2012 incident, he was sued for 4th Amendment constitutional violations due to excessive force. Lacy lost this case and the judge ordered payment of $12,000 for the incident. In the summer of 2021, 19-year-old Alexis Wilson was shot 7 times and killed by Dalton police. Her mom emailed us twice, pleading with us to expose Officer Lacy. Activists Carlos West and Rabbi Michael McLennan protested this killing 7 days later, exercising their constitutional right to free speech. However, their rights were violated by Officer Lacy once again when he ordered their arrest without due cause. They filed a lawsuit, and on March 4th, both of these men were awarded $50,000 in settlements. This is one of Mayor Tiffany's lead lapdogs that she uses to control the town through his goonish actions. Another case he was involved in resulted in the largest settlement in Cook County history, $33.5 million.
You guys step over here on public property.
This is not public property. Where is public property?
Now, you got to go over to Tommy G's channel and check that video out.
Yes, we went over this video as well. Tommy G is just absolutely epic. He went there and these corrupt, dumbass cops demanded that he ID himself out in the public space. And he did not have to legally do that. And they bullied and threatened and intimidated him. Lacy does not know the law. And this is why he's now having to take FBI plea deals, because he's an idiot. I still hope that plea deal results in him going to prison. Can you imagine the chief of police going to prison? I want you all to think about that for a second. Y'all know chief of police, people who have put other people in prison don't do well in prison themselves. So now you can imagine him being in prison, probably sharing cells with many of the people that he helped put in there himself over some corrupt bullshit. Oh, he got it coming. Hey, Lacy, watch out for Debo and them.
When Lacy harassed Tommy G. Now, for those of you who don't remember, Chief Lacy was facing 9 charges in that bankruptcy fraud indictment. Okay, so this is a 9-count indictment against Louis A. Lacy, former acting police chief of Dalton. So here they talk about Louis A. Lacy as a police officer in Dalton. They talk about the bank accounts that Lacy controlled. Then we get into the details of what happened. Now, the indictment points out something pretty interesting, that between 1984 and 2019, Lacy filed a total of 7 bankruptcies. One of the tricks the government alleges Lacy did on the bankruptcy filing is totally pretend that he and his wife had separated when they say, quote, here, Lacy, well knowing that he was married, not separated, and that his non-filing spouse was residing with them, earning income and contributing to the payments of Lacy's expenses, did not disclose his non-filing wife's employment, occupation, employer, monthly income, and falsely represented that his combined monthly income was approximately $49.95. And the government alleges that if you add his wife's income to his income, which you're supposed to do in bankruptcy, it would have been substantially more. He also did things like tell the government his net income in a given month was $617. Now, former Chief Lacy is facing 9 counts. Now, that's because every time you lie on a form or lie to the government, they're charging you with 1 count. So he is being charged with 9 counts. Chief Lacy's lawyer responded to these charges.
I spoke this afternoon with Lacy's attorney. He called today's charges a witch hunt designed to get another Henyard ally to turn on her in this ongoing investigation into her spending.
That's exactly what the U.S. attorney does every single time. They start with people that they believe that they can flip. They go down the line.
I want you all to pay attention to what he just said. They do that every single time. You know why? Because it still works. It still works. It's like the blood. It still works. It still has power. This is what we are. They're upset that the FBI is still using tactics that still works. And it has worked for decades. Since the inception of the FBI itself. It still works. Look what happened. He took a plea deal. I thought Lacy was trying to hang in there and tough it out. Yo, Lacy, you're not that rough or tough with your pillow puff. Yeah, his ass is a pillow. Can't make this up.
They show up at 6 o'clock in the morning when a person is not lawyered up, when a person is just waking up, and they're telling you, oh, I'm here to talk to you and be nice to you and don't worry about it. And you're not under arrest. And then we're going to leave and we're not going to arrest you today. But here are some questions that we have for you. So immediately a person puts his foot in the mouth and from there, they're the fish is caught.
Is that what they did with Lacy?
To a certain degree, yes.
So I'm not too sure what Lacy's lawyer said. It sounds like they had a conversation with him. He put his foot in his mouth and now they're flipping him like a fish. Who knows? But that's my opinion based on what I just heard. So now, because he's put his foot in his mouth, he pleads guilty and decides to cooperate with the federal government against Henyard. Here is WGN. Former Adult Police Chief Louis Lacy has agreed to plead guilty.
What's up, Lacy? You didn't have to accept the plea deal. You could have went to trial, you dumbass. That's the thing here. He's whining about something that didn't have to happen. He could have went to trial. You can't make this up. Oh, how y'all doing? Shout out to all of you all tuning in. Did I get no on there? Belinda up in here. Y'all good? Oh, y'all can tell my voice is, yeah, it's trying to loosen up, y'all. Chris help, what's going on? Tiffany strikes again. She showed it. There you always have the great info. Oh man, there's so many fantastic content creators out there, but I, the queen of YouTube. Yep, y'all know I'm gonna drop it down. And I love going over court documents. It's fun for me. Lacy did not have to accept the plea deal. He could have said, nope, I want to go to trial. And that's it. He has the right to a trial. Lacy, you had the right to a speedy trial. No one told you to do this. No one told you to go and get an attorney and then say, I want a plea deal. No one told you to do that. Why didn't you go to trial? Because, we would have had a good time covering that. He's a coward. He knows he does not want to go through that because, see, you go through a trial, guess what they got to present? Evidence, testimony. They're going to have witnesses. And then you're leaving it in the hands of a jury. And when you've lied and perjured yourself, the last thing you want to do is go to trial and then be ordered to testify. And then you get cross-examined. Because his attorneys would not have allowed him to testify. He's already perjured himself in affidavits. So whether you perjure yourself in an affidavit or you perjure yourself on the stand, you still perjure yourself. You're still lying. When you have a history of lying like hell, the last thing you want to do is to go to trial. But he didn't have to take a plea deal either. He could have went to trial. Yeah, he thought he was smart. So, so here we are. He's taking this plea deal. We got a copy of it. We're going to go over it. But no one told him to do this. No one told him to do it. What's going on, John? Our praises to be the most high. Good morning to you all. Good morning, LLC. You are loosening your voice. Y'all, I had a very busy day yesterday. I also had fun. I went outside and played around with the kids. Kickball, soccer, something, a little bit of volleyball. We had fun. We had fun. Might do that again today. So the pollen sometimes gets to me, so y'all excuse my voice. Oh, thank you so much, Ralph Mars. The lady he was harassing at the Easter party said Charm is going to get you. Charm? Oh, Lord. What's going on, Status Quo? How you doing? Thanks for covering this LLC, and I'm watching. Thank you, Status Quo. Long time no see. Hope all is well. Oh, y'all, yeah, we're going to get back on this with the Tiffany Henyard thing because I told y'all as soon as the FBI start making some moves, I was going to be back on it. Plus, nobody controls the internet, nor does anybody run the LLC. I report on what I want to report on. And super stupid is still dumb. Can't make this up. Let's get back to it.
In a personal bankruptcy fraud case and is cooperating with a broader investigation according to the language in his agreement with the U.S. Attorney's Office. Lewis's plea agreement specifically states that he agrees to provide complete and truthful information to any investigation and any criminal, civil, or administrative proceeding. Now, the weird part about this is the second person in Tiffany Henyard's administration to be indicted on bankruptcy fraud charges. Remember Keith Freeman?
As WGN Investigates was first to report today, a top aide to Dalton Mayor Tiffany Henyard has been indicted for bankruptcy fraud. It comes amid ongoing questions about Henyard's spending and leadership.
And legal experts say it could be the first sign that the feds are trying to get people to share what they know about potential government corruption in the South suburbs.
Senior Administrator for Dalton and Thornton Township, Keith Freeman, pleading not guilty to bankruptcy fraud. His attorney speaking with reporters after the arraignment.
We've had a couple of questions directed to me about whether or not this indictment means that the government is effectively trying to squeeze Mr. Freeman into cooperation. And I think that question is a question better put to the government.
Now, after all that, Keith Freeman, the former Dalton administrator, has asked the court to change his plea from not guilty to something else. Illinois Leaks report, former Dalton administrator Keith Freeman's change of plea on his federal bankruptcy charges postponed until March 4th, 2026. This is the fourth or fifth time it has been postponed, which makes us think other things may be in the works. So this answers a couple of my questions. Like, number one, why was this taking so long? Let's think about it. Your two key witnesses, the police chief who was doing all your dirty work and the finance guy who was spending all the money funny, if you get them both locked up, then the government's case becomes really, really strong. Lacy obviously was in a lot of trouble. He's facing 9 counts. So guess what? In December 2025, Lacy pleads guilty and turns state's evidence, saving him a long prison sentence. So now the feds have the enforcer locked down. Next, you go after the money guy. Where is he vulnerable? Bankruptcy fraud. But Keith Freeman's time has run out. Here is the last minute entry for Judge John F. Neese. Essentially said the parties reported additional time is needed to prepare for a change of plea hearing. Accordingly, in-person change of plea hearing is set for March 4th, 2026 at 10:30 a.m. If the change of plea does not go forward, the court will set a trial date at the March 4th, 2026 hearing. So if March comes around and there's no plea, they are going to trial. So we get to see if the government ties up the Keith Freeman loose end, because I think if they get Keith Freeman, they've already got Lacy, it's pretty much over for Henyard. So it seems like they're getting their ducks in a row, and next on the list is going to be Tiffany Henyard eventually, because I don't see the federal government putting in all this work and all these indictments and arresting all these people and asking them to flip in their agreements if they don't have anything or not going after. So we'll see. I'll keep you updated. But as of right now, it seems like the wheels of justice are in motion. So that's my update for Tiffany Henyard and Dalton. Don't forget, like, subscribe to like our YouTube stuff. My name is Nate the Lawyer, and I'll see you in the next one. Peace.
Oh,
Hi, Shark.
I'm so glad that we got that in. Shout out to Nate the Lawyer. Y'all ready? Keith Freeman, you're up, you moron. Y'all, he thought he was just gonna be able to skate away from this. Oh, we got it. Oh, Keith Freeman. 31 pages. Yeah, you changed your plea, huh? The U.S. District Court, Northern District of Illinois, Eastern Division, U.S. of A.V. Keith Douglas Freeman, number 24CR191, Judge John F. Ness. Is it Ness? Ness. Kness. I think that's Ness. Plea agreement. Y'all ready? me. Keith Freeman is a coward. So much for him going to trial. The plea agreement between the United States Attorney for the Northern District of Illinois, Andrew S. Boutros, and defendant Keith Douglas Freeman and his attorney Joshua G. Herman is made pursuant to Rule 11 of the Federal Rules of Criminal Procedure. The parties to this agreement have agreed upon the following charges in this case. The superseding information in this case charges defendant with devising a scheme to commit bankruptcy fraud in violation of Title 18 U.S. Code Section 1572, Count 1, and filing a false tax return in violation of Title 26 U.S. Code Section 72061, Count 2. Defendant has read the charges against him contained in the superseding information, and those charges have been fully explained to him by his attorney. Y'all remember when I said the last time I reported on this that I would not be surprised if there was a superseding indictment? That's what this is. Yeah, because Lady Luck Club does not miss. So he has a superseding indictment. And they went over all the charges, because when you're under investigation, the investigators can take any new evidence that they find. And if the requirements for a charge can be rendered based on that evidence, and the law is applicable, meaning, let's say you get charged with fraud, and one of the requisites for fraud is intent. So if they're able to show intent and they have sufficient evidence under the law, they can charge you with additional charges while you are under investigation, even if you've been charged. So it's like making an amendment, except this charge here, the new charges is going to supersede the previous indictment. So a superseding indictment is typically an amended indictment with additional charges added on to it based on any new evidence that they came across to warrant those new charges. Does that make sense? Hit the phone. Because I want to make sure we all understand when we see superseding what that means. So he chose to accept this. No one told Chief Freeman to do this. He chose to do this. They don't coerce or force you to do it. They would rather you go to trial and then present all their evidence, and then a jury finds you guilty. And then you sit in prison for like 7 to 10 years or however long. But either way, they're going to secure something. Either you're going to go through a plea deal because the FBI goes in with a conviction rate of 99.99%. Or if you decide to go to trial, then you risk that prison time. All of it. Y'all, this is so crazy. He chose to do this. Chief Freeman wanted this. So this was basically the plea agreement itself. Includes superseding charges that were rendered after the original indictment had already been filed. All right. Defendant fully understands the nature and elements of the crimes with which he has been charged. Charges to which defendant is pleading guilty. By this plea agreement, defendant enters a voluntary plea of guilty to the following counts of the superseding information. Count 1, which charges defendant with devising a scheme to defraud and for the purpose of executing and concealing the scheme and attempting to do so, filing a document in a proceeding under Title 11 of the U.S. Code in violation of Title 18 U.S. Code Section 1572. And count 2, which charges defendant with filing a false tax return in violation of Title 26 U.S. Code Section 72061. Factual basis. Defendant will plead guilty because he is in fact guilty of the charges. Oh, I love it. He is in fact guilty of the charges contained in counts 1 and 2 of the superseding information. I'm just going to kind of skim through it. With respect to count 1 of the superseding info, on or about January 3rd, 24, here's where they get into the background information. At Chicago, in the Northern District of Illinois, Eastern Division, defendant Keith Douglas Freeman, for the purpose of executing and concealing a scheme to defraud and attempted to do so, filed and caused to be filed a document, namely schedules and a statement of financial affairs, in a proceeding under Title 11 of the U.S. Code, namely a Chapter 7 bankruptcy case. So he filed an affidavit in a bankruptcy case that was fraudulent. He lied like hell. Okay, that's what that means. He provided false information, which would fit the criteria of intent to defraud under these, this bankruptcy proceeding. Specifically at times relevant. Yeah, I'm just kind of going through because it's 31 pages and I don't want to keep you all forever and ever. Specifically at times relevant to the scheme, Freeman was employed as the village administrator of the village of Dalton, the municipality manager at Thornton Township, and the village administrator of the village of Robbins. Doesn't he owe them money? Keith Freeman, did you ever pay those people that $90,000 you owe? Y'all ever heard him pay the village of Robbins that money back? Let me know in the chat if you heard it, because he owed them some money. Oh man, he's gonna catch it left and right. I hope he paid them back, because if not, he need to get a payment plan. Can't make this up, man. And received consulting fees from a business company A that financed the lease purchase of firefighting and other equipment by municipalities and governmental organizations. So he had contracts with the village that he was employed with, and probably did not disclose this as well, because the shicey stuff that they did, you can't tell me that Super Stupid did not know. You can't tell me that. You got these people up here filing false tax returns and going to bankruptcy court. She knew that they were going to bankruptcy court and filing bankrupt. She knew that he was the village administrator and had a contract for firefighter equipment. So he's making money from the village that he's also employed with. Question is, did he disclose that conflict of interest? And I highly doubt it. Child, they tried to lie about how much money they were making. You can't make this up. He was also the sole owner of Government Staffing Advisors, Inc., GSA, which he incorporated on or about July 12, 2023, and an owner of Keith Freeman, LLC, doing business as Doodah's Novelty Store. What kind of novelty store is that? Hey, don't tell me it's the Kiki kind when he's selling whips and chains and y'all. He had a novelty store. What the hell did that look like? Keith Freeman, what were you selling in this novelty store? Don't make me look this up. Do I need to look up Doodah's Novelty Store, y'all? What we gonna find in this novelty store? I hear something like that, you know, you thinking about like, oh Lord have mercy. Doodah's, did I spell this right? I'm looking this up, y'all, because this is something else. Doodah's, Doodadz. Y'all, this is crazy. A novelty store? What type of novelty store is this? This can't be it. That can't be it. Doodah's, Doodadz. This is on Facebook. This cannot be it. Y'all. What the hell? Why does it look like Halloween baskets and some pumpkins in here? Is it candles? What the hell is this? This can't be it. Oh no, this cannot be his novelty store. Hell no. Is it Doodah's for real? Y'all, this is crazy. Hold on, let me see. There's some on Instagram. Doodah's, this is the only thing that's coming up with Doodah's. Y'all let me know if y'all find something else, but I highly doubt this is his stuff. With two white women here standing next to a Santa Claus. You can't make this up. He lied like hell. He lied like hell. Y'all come across something else, let me know, but that's all I'm finding. With the spelling of that, Doodah's. Yeah, no, I'm not seeing anything that would look like he would sell something. Yeah, it's pumpkins and Santa Claus and gift baskets. What the hell? Oh, Keith Freeman, you lying ass piece of crap. You can't make this up. He just took somebody's business. Y'all, this is so crazy. Can you pull a business from the state? Probably. But the thing is it real? Like Doodah's Novelty. If I pull the business license, novelty store, let's put Illinois. Doodah's. The only thing that's coming up with Doodah's is this boutique here we just got through looking at on Facebook. This is their website with these same two women, and Instagram, which is the same thing. Chamber of Commerce. Let me see. No, that ain't it. I'm looking for it doesn't even have that on the. Yeah, see, on the Chamber of Commerce for Illinois, no results found. So did he just make some up, or he stole somebody else's LLC? He just put a name on here. This can't be real. Y'all see this? This is on the Chamber of Commerce website. Doodah's Novelty Store, Illinois. Nothing. It's insane. Did he absolve the company? Y'all, this is nuts. I have never seen this. This man probably took someone else's LLC and just used it as a cover. Because the only thing coming up Doodah's was the website with the two white women selling pumpkins and, you know, decorations and stuff. Y'all, that's crazy. That's some crazy work right there. Oh, Keith Freeman, you're an idiot. You deserve to be in prison. Can't make this up. So He had Keith Freeman LLC DBA Doodah's Novelty Store. Lord knows if that was real or not. May not even been his. Probably just used it. Yeah, that's so crazy. Sounds like it's or sold it. Yeah, he could have sold it. I think he may have absolved it. Beginning in or around July 23 and continuing until in or around April 24 at Chicago and Orland Park in the Northern District of Illinois Eastern Division and elsewhere, Freeman devised and intended to devise a scheme to defraud for the purpose of executing and concealing the scheme and attempting to do so filed and caused to be filed documents in a bankruptcy case under Title 11 of the U.S. Code and made materially false and fraudulent representations concerning and in relation to that case. Yeah, so he lied like hell and perjured himself. Because that's all he did anyway. He lied like hell. Lied for Tiffany Henyard. Lied on Tiffany Henyard. Lied about her. You know. And then when you're going through these plea deals, you have to cooperate to the fullest. You can't go into a plea deal half-hearted. You have to go into that plea deal with substantive evidence, meaning you can't lead them down a dead end. You can't lie to them. You can't sit here and twist anything up because they will revoke this and they will lock your ass up just for playing in their face and still lying to them. So when you come, you better come correct if the FBI is offering you a plea deal. I'm telling you all right now, they don't like that stuff. Don't piss him off. So he must have a lot of evidence and information that he is giving over on Tiffany Henyard because he lied like hell to them multiple times. He's got 2 charges that he's pleading guilty to here. Let's go scroll down some more here because, like I said, I don't want to read the whole thing. Let's go to this one. On or about January 3rd, 24, Freeman filed a bankruptcy petition in the U.S. Bankruptcy Court for the Northern District of Illinois, thereby initiating a Chapter 7 bankruptcy case, captioned in re Keith Douglas Freeman number 24-00059, the Freeman bankruptcy case. And I actually went over that indictment for both Keith Freeman and Louis Lacy. So the same day Freeman filed in the Freeman bankruptcy case his schedules and a statement of financial affairs signed under penalty of perjury. So the affidavit is where he lied, and he signed attesting that the statements were true when they were not. All right. I'm not going to go through the nuances of all of these schedules because it's a lot. When you're filing for bankruptcy, you have to tell them about your entire financial life. Every penny that you have. Where is it hiding? All your revenue, all your expenses, any assets, anything that can be liquidated. They want to know it all. Because you're telling the government you can't pay your bills. You can't pay your debts. And you need to be absolved. And so when you lie like hell like this, they're like, so you could have paid these debts and bills. And you're doing this just to get away with not paying your bills. That's some lazy ass shit, Keith Freeman. Can't make this stop. Yeah, I would love to be able to just say I don't have to pay my rent for a year, but you know I have to. It is what it is. Can't make this up. With respect to count 2 of the superseding information, on or about May 31, 21, at Hazel Crest in the Northern District of Illinois Eastern Division, Freeman willfully made and subscribed a U.S. individual income tax return form 1040 with schedules and attachments for the calendar year 2020, which return was verified by written declaration that it was made under penalties of perjury. So when you do your taxes, you are declaring that the information is true and correct under the penalty of perjury. Yeah, that's how they got Al Capone. Al Capone murk people. But he went to prison for over 11 years for tax evasion and tax fraud. Stop playing with the IRS. Oh, Keith Freeman. Y'all, this idiot never learned. Oh, my good grief. Oh, man. What's going on, Camille? How you doing, honey? Hey, Belinda says, why do people do this? Never understood why you want to lose your freedoms for what chump change. Yep. And to cover up other issues, other bigger problems that you're doing with someone else. They call themselves trying to protect Tiffany Henyard. Super Stupid is a grown-ass woman. It's high time for those training wheels to come off, Tiffany. Oh, Tiffany. The training wheels are coming off. Keith Freeman and Louis Lacy have taken plea deals. Any and everything that they are involved in concerning you, they will be telling the FBI. You running for Fulton County Commissioner will not stop that from happening. I think that's what she thinks is going to happen. They can't come get me if I'm running for election. Nah, they gonna get your ass. Now, you've been under investigation this whole time. It's not like it's going to start the moment you say you running and you're on the ballot. No, they've been investigating you before you were on the ballot. So it's not going to stop. And you're not going to win anyway. So, they'll lock you up. They don't care about that. Yeah, it's so crazy. Status Quo said, enter Doodah's novelty store plus Keith Freeman. Hold on. All right. Because I want to see what type of products he's selling. Doodah's novelty store, Keith Freeman. Oh, what I get is some. Let me see. Something came back from the U.S. Department of Justice. I think that was his indictment. Y'all, this is crazy. Hold on. Justia trademarks. Okay, I see what you're saying. Ooh, let's see. Okay, this is the only thing that comes up. Shout out to you, Status Quo. Machines, namely heat transfer press. Are you looking at the same thing I am? This is it. Doodahs, filed August 13, 2021. Machines, namely heat transfer presses. Machines, namely sublimation heat transfer presses. Power operated grass weed, blah, blah, blah. Operated, owned by Keith Freeman, LLC. Serial number 90881908. So this must have been grass and weed. What? What do you do? Make t-shirts? Heat transfer presses? Sublimation heat transfer press? What do you do? Make t-shirts and cut grass? Y'all. This says that it was filed, the LLC trademark was filed August 13, 2021. Is it still up? It must have been absolved. Oh, here it is. Hold on. I had to click on the number. Y'all see this? Okay, status 630. New application. Record initialized, not assigned to examiner for Doodahs. Here's the same serial number. Doodahs 630. New application. Status date was August 17, 2021. Filing date August 13, 2021. 4,000 standard character mark typeset. And then here's the good services. Power operated grass weed trimmers and some heat presses. Online retail store services featuring heat transfer paper, heat transfer vinyl, sublimation products. This was his LLC as Doodah's novelty store. How is this a novelty store? Yeah, you think novelty, you think, these little baskets, or you think it's something, kinky like. But how is this? You selling heat transfer presses and power operated grass weed trimmers. How is that a novelty? Was this classified correctly? Or I think he just did anything. He just selected any category. And he really didn't sell anything at all. And just kind of used that to funnel money. Like money laundering. So let me have this LLC and have it set up. When I do business, I'm doing business under this Doodah's novelty store. So that the transactions, it looks like this business is operating, transactions are being done under this LLC. And then, transfers the money out of an account related to this and put it in another account. So the real transactions, like what the purposes of what he's truly buying or transferring money around for, stays concealed, because he can say, well, this was for my business. So I got $2,000 that came through that went to the account related to my Keith Freeman LLC for novelty doodahs, novelty store. But then the $2,000 turns out to be some payments he got from the village of Dalton. Just hypothetical. But he's hiding those transactions under this LLC. So that could be possibly money laundering. I sure hope they get his ass on that, because there is no way. You're talking about an online store. Y'all look, an online retail store services featuring heat transfer, paper, vinyl, and sublimation products, grass and weed trimmers. Online store. We couldn't even find the website. So that lets me know that this was a dummy LLC. And he probably had an account related to it where he was hiding money. Now, I can figure that out just by looking this up. Imagine what the FBI can do by actually pulling any information related to this LLC and any accounts connected to this business, so-called business. Because if he got this business, trust and believe he has a business account as well. Probably a couple credit cards and everything else. Because online retail store, anyone can have that. And then if you're not really checking for it, or if you're not advertising it, there are no true sales happening with it, then it can go a long time with you using the accounts and anything related to it to avoid it being in your name. Y'all, this is crazy. Thank you, Status, for that. Y'all, he could act as a buyer of equipment. Yep. I think that was some money laundering going on in here. Y'all hit that like button. There you go. Let me drop the link in the chat, because I like to give you all the sources that we looking up. Shout out to Status Quo and to Melinda. There you go. You guys make sure you go check that out. But this is how you end up with charges of money laundering. When you're using accounts for the intents and purposes of hiding money, and then you get to say, I didn't earn X amount of dollars, and it doesn't come up because this LLC is separate from your personal income tax. So you're not even reporting that income that you got hiding in an account related to your Doodah's Novelty Store LLC. Does that make sense? So he put money in that account to hide it from the IRS to make it seem like he's not earning so much money. So the lower his salary, the lower his taxes that he pays. Probably gets a bigger refund. He probably even requested for a PPP loan. Who knows? I wouldn't be surprised if we found that this LLC is sitting on a PPP loan list where he got some money from the government for PPP loans during COVID. I would not be surprised at all. And he probably put that money in the actual business account connected to Doodah's Novelty. So I hope they get his ass on fraud. Y'all know he one of the ones that look like he would do some PPP loan fraud. Boy, just a little bit of Googling. Man, listen here. Look at this. And here's the Bizpedia. Oh, y'all, this is good stuff. This is good. So this helps you all understand the charges that he pled guilty to two counts, right? But imagine if he went to trial. All of this could have came up in the trial. All of this evidence. He probably would have been hit with money laundering as well. Because just saying I have an online retail store, but no one can find it. You selling power trimmers and grass weeders and stuff. Man, come on. He's not selling that shit. Y'all, he lined his butt off. Oh man, so Bizopedia got it too. These stupid commercials. Trademark overview. This trademark is held by Keith Freeman LLC, with the application originally filed on August 13, 2021, and later registered on September 6, 22. According to records maintained by the U.S. Patent and Trademark Office, USPTO, the mark is currently listed as registered, with the status last updated on September 6, 22. The application is identified by serial number 9088-1908 and registration number 683-8495, which are used by the USPTO to track the life cycle of the mark. The application has been processed through L70 Law Office 107. As of the latest update, the case is listed as publication and issue section. The mark was published for opposition on June 21, 22. Here it is right here. Court information last refreshed February 1 of 24, 2 years ago. And then his mark identification is Dudas. You all see him as the last applicant / owner. Address here, serial number, registration number, filing date, and it says registered. That's in good standing. Can y'all believe it? Y'all see this? It's in good standing. It's registered. Oh man. Oh man, there is no way they did not know about this. They have to know about this. So they got the registration number, the serial number. It says registered. And then case file information here. All correspondence go back to him. Naturally. Law Office 107. Who knows what that is? Employee name, Troy Frank Knight. Who is Troy Frank Knight? He got an employee. Current location, publication issue section. Who is this person? Y'all ever heard of Troy Frank Knight? Y'all see that here? Employee name. Is that his attorney? Because he got the correspondence going to himself. What the hell? Y'all, this is crazy. Location, transaction date, January 25th, 24. I've never heard of Troy Frank Knight. If you all have, let me know. Dates correspond to shift. SHTF. What's that acronym? Correspondent. Y'all see that here? I'm trying to figure out, does he have an attorney? Law office assigned? That might be his attorney. I don't know. Y'all, let me make sure I drop the link on this too for Bizpedia. Did I put that in there? Yeah, here it is. You guys make sure y'all go check this out. I can guarantee you all the FBI has all of this because they want to know any account that you have where you could have possibly hid money in. They're going to uncover it. And if he had this LLC doing business as Dudas, he has some accounts connected to it. Machinery. Yeah, you can't make this up. But this is supposed to be advertising and business. This is supposed to be an online store. He claims it's an online store that's operating where he's selling heat presses, vinyl presses, and some grass and weed trimmers. All it is. Boy, he went out his way to lie like hell. Y'all see that? Online retail store. That's what this is supposed to be. Where's the website? Oh man, the last thing you want to do is lie to the court. And you know he had to be hiding money in an account connected to this Dudas. Oh, you can't make this up. This is priceless. Keith Freeman lied all over the place. Oh, Keith Freeman. I don't know how this LLC is in good standing. It's registered, rather. It has not been absolved. But yeah, if they got their hands on this and they figured out, there's some accounts connected to this, I don't think he'll have a choice. It's not that he's really active with it. I mean, last thing done with it was February 1 of 2024. So I highly doubt he refreshes this or does anything after this because of this plea deal. Because a lot of times, once they figure out, okay, we want to know all your business. We want to know where any penny that you may have received with income, revenue, whatever. We want to know where everything is. More than likely, he's not going to be able to continue to utilize this unless they, realize it was something legitimate. But I haven't even seen an online store either. Y'all, this is crazy. Oh, hitting the fan, LLC. Okay. Ghost employee. Thank you. They score response and shit hitting the fan. Gotcha. Yeah, see, I learn something new every day. It's a ghost employee. Gotta be a ghost employee. Never heard of that Troy Knight person? Troy Frank Knight. Never heard of him. He could have, man, it sounds like something he just put down. Let me just put down Troy and a Frank and a Knight. Yeah, that'll work. Because if it was his attorney's information will be over here. Like, if you have an attorney, just name your attorney. It's so stupid. Oh, Lord. All right, y'all, that's that for that doodah thing. Yeah, he up here hiding money everywhere. Let's get back to this and finish this up. So he filed the individual tax return. He stated that his total income was like $50,000. He lied like hell on that. Specifically on May 31, 2021, Freeman, a resident of Northern District of Illinois, prepared, signed under penalty of perjury, and filed with the IRS more false statements for his tax filings. He put down that he earned an income of $50,000. And then he knew at the time of the filing that he had received additional income of at least approximately $254,543 from other sources, namely $79,743 from the village of Robbins and $174,800 in economic injury disaster loan. What I tell y'all? PPP loan. Oh, that's the PPP loan, y'all. The economic injury disaster loan in 2020. Yeah, that's that COVID PPP loan. I told y'all, PPP loan fraud. Why didn't he get his ass on that? Oh, man, he lied like hell. Y'all, he received a total of $254,543, but reported that he only received $50,347. What in that entire? How do you come up $204,000 short? He didn't even try. He didn't even get close to it. That's just the fourth of this amount. Y'all, this is insane. Insane in the membrane. So he told them, I only got $50,000. How you living off of that? You got a house, how much that mortgage costs? Y'all, by the time they do the math and add up all your expenses, they're going to be asking you, how are you living? And then he had a spouse and kids. How you taking care of them and driving this nice car and living in this nice home? This is your mortgage on $50,000. It wasn't even reasonable. When he, in actuality, received $254,543. You can't make this up. They was like, oh, hell no. He resulted in a loss. He's reported a loss of $82,077 and a loss to the Illinois Department of Revenue of approximately $12,321. Child, he underreported his income and caused losses of approximately $24,346 in 2019. So he was lying for at least 2 to 3 years in a row on his taxes. So the 2019 tax return, he reported that he had losses of $24,346. And 2020, $82,077. That's to the IRS. That's not including the Department of Revenue. So you file your federal income tax statements and then the state tax filings. And that's what he reported. Lying like hell. So let's scroll down some because, like I said, this is 31 pages. Y'all, this is something else. This goes into, y'all see this? The Coronavirus Aid, Relief, and Economic Security Act was a federal law enacted in March 2020 and designed in part to provide emergency financial assistance to small businesses that were experiencing a temporary loss of revenue as a result of COVID-19 pandemic. One source of relief provided by the CARES Act was the expansion of the EIDL program. And that's what we just read up here. The Economic Injury Disaster Loan, where he received $174,800. PPP loan fraud. I told you all that PPP loan fraud is something else. So he lied like hell. He got money under this PPP loan from the COVID and used all these LLCs to get these PPP loans. And then he didn't even report it. You can't make this up. He didn't even report it. He said that he only got $50,000 that year when he got $174,800 from a PPP loan in tax year 2020 and did not even report that to the IRS. Keith Freeman is a dumbass. You can't make this up. And she hired these people. Super stupid, kept these people around her in her inner circle. Tiffany Henyard knew that he received this PPP loan and said nothing. She knew he was trying to file bankrupt. She knew that he had not reported this stuff because they talk. How do you have your chief of police and your right-hand man both doing the same fraudulent crap? Make it make sense. How do you get $174,800 in PPP loans from the government, but not report it to the government on your tax statements? That's how stupid he is. Yeah, I'm going to take the federal government aid as a loan, but I'm not going to report it to the IRS. You do realize they know they gave your ass money, right? They have it on their end that they gave his ass over $174,000, and then somehow it never shows up on his tax returns. Like, oh my God, he playing in their faces. He tried to play in their face, and they were like, nope, we're going to get your ass. Oh my good Lord. So yeah, he got those funds and then failed to report it on his tax returns and provided materially false and fraudulent information to them. Knowingly and willfully did that with the purposes of executing this scheme to lie like hell. Defrauding the government is a whole thing in and of itself. And the submission of a false and fraudulent EIDL application in violation of Title 18 U.S. Code Section 1343 is a violation of federal law. I can't believe the crimes that he and Lacy committed were so stupid, and it was so obvious. Like, numbers don't lie. And in the IRS, they know that you were issued a payment from the COVID relief program because they have it on their end. Why would you lie and say, I didn't get this money? You didn't even report it. Yeah, he didn't even try. All right, let's get down to the section that says maximum statutory penalties. Because what's going to happen later, Luck? How long he going to prison? I'm glad you asked. Defendant understands that the charges to which he is pleading guilty carry the following statutory penalties. Count 1 carries a maximum sentence of 5 years imprisonment. Count 1 also carries a maximum fine of $250,000. Defendant further understands that with respect to count 1, the judge may also impose a term of supervised release of not more than 3 years. So, more than likely, his plea deal would be the penalty of it anyway, under the plea deal, would be supervised probation for the 3 years as opposed to 3 years in prison. And then he has to pay the fines. Who knows? But the judge also has discretion. Preferably, the judge says, no, you still need to go to jail. But I think that would be depending on the type of information he provides for their investigation concerning Tiffany Henyard too. Because if you lie to them about you not getting some money they gave you, if you're willing to lie to the IRS, to the government about a PPP loan, and they know they gave you this money, the IRS has a record of it on their end, and you don't file it on your tax return, he probably would not have any issue lying about Tiffany Henyard. So they have to ensure that the information he's giving them is substantive and viable, meaning it has to be material to their investigation that they can actually use in a court of law. There will be evidence to support it, and they'd be able to nail her ass with it. Because otherwise, they don't want you blowing smoke in their face. You've already done that. But if it comes down to it and they revoke this plea deal, then he'll be facing the maximum time. And then he can get a trial, jury trial. And if they find him guilty, which more than likely they would, considering the fact that he's taking a plea deal, because their case against him is very strong. And they have enough evidence to get a conviction, right? So if they revoke the plea deal, then he'll go through the trial hearing. He'll still be found guilty because their case is too strong. And he'll end up getting the maximum time. So this is what he's looking at if he doesn't cooperate. The judge can use discretion and still say, nah, you're going to go to prison. You may not go for 3 years, but you're going. And then you still got to pay all these fines. And when you get out, you're still on supervised probation. Does that make sense? So the judge could use discretion and accept the whole plea deal or in parts. Most times the judges aren't going to just ignore the entire plea deal altogether. But the judge could amend or alter the plea deal or add additional, penalties, additional fines, community service, maybe even jail time. They can do that. They have the discretion to do that within the confines of the law, right? So if the plea deal is like, okay, the maximum prison time is 5 years, we're saying give him 3 years, let it be probated. But the judge could say, well, I'm going to give him 4 years because based on the law, 5 years is the penalty, the maximum. But I'm going to give him 4 years. 3 of them would be probated. 1 of them, he's going to have to serve. The judge could do that. That's what I'm hoping for. If found guilty, pray the court makes sentences consecutive, in my honest opinion. Yeah, it would be. Both these charges would be consecutive. I would hope so. So count one carries the maximum sentence of 5 years imprisonment with a maximum fine of $250,000. Defendant further understands that with respect to count 1, the judge may also impose a term of supervised release of not more than 3 years. Count 2 carries a maximum sentence of 3 years imprisonment. Count 2 also carries a maximum of fine of $250,000. So he could easily be ordered to pay $500,000 with both counts combined. My bad. Defendant further understands that the court must order cost of prosecution estimated not to exceed $500. Defendant further understands that with respect to count 2, the judge may also impose a term of supervised release of not more than 1 year. Pursuant to Title 18 U.S. Code Section 3013, defendant will be assessed $100 on each count to which he has pled guilty, in addition to any other penalty or restitution imposed. So, when you're ordered to pay the restitution, in accordance with the law, let's say the judge assesses the $100 and then adds on the additional $400. The estimated not to exceed $500. So he could face getting ordered to pay restitution of $500 for count 2. In addition to the maximum fines. I hope he gets the maximum fines because his ass been hiding money. Boy, that maximum fine is gonna whoop his ass. $500,000. That's a lot of money. Oh man. The court may also order restitution to any victims of count 1 and count 2 as a condition of supervised release, or otherwise to any victims as agreed by the parties pursuant to this plea agreement. Therefore, under the counts to which defendant is pleading guilty, to the total maximum sentence is 8 years imprisonment. Woo, child. Woo, what you say, consecutive? There you go. 8 years imprisonment. 5 plus 3 is 8, Chief Freeman. Because he doesn't know math. Oh, Lord have mercy. So the 5 years from count 1, 3 years from count 2 gives you 8 years. Oh, man. Give him the max. This is priceless. In addition, defendant is subject to a total maximum fine of $500,000. Mandatory costs of prosecution, a period of supervised release of up to 4 years, and special assessments totaling $200, in addition to any restitution ordered by the court, which would be the judge's discretion. And I hope they use it. So they have these sentencing guidelines calculations here that's listed under law, what the guidelines are. That's for every, charge. There's always a sentencing guideline inapplicable with federal and state laws. So I'm not going to read that as boring stuff. Applicable guidelines here, the sentencing guidelines to be considered in this case are those in effect at the time of sentencing. All right. So the guidelines could change or be amended, but they go based on what was in effect at the time you were sentenced. The following statements regarding the calculation of the sentencing guidelines are based on the guidelines manual currently in effect, namely the November 1, 2025 guidelines manual. All right, offense level calculations, count 1, and that's pursuant to guideline 3D1.2D, count 1, and the stipulated offense group. Base offense level is 6. There is semantics here with the sentencing guideline, but they're going over how much he lied about with regards to the losses, the debt, then the offense levels for each offense, the charges. Count 2, same thing, based on how much he lied about. Like if you have a charge of defrauding the elderly, the minimum for that charge is $50,000. Does that make sense? So for each of these charges, the amount of money that he defrauded, there has to be a minimum amount that he defrauded in order for certain charges to be applicable. Does that make sense? So if you defraud the elderly and you get charged with defrauding the elderly, the amount must be minimum $50,000 in order for that charge to apply. And then the sentencing guideline, based on the amount of money you have defrauded, can also determine the length of prison time, restitution payments, and the fines and fees that you pay. Does that make sense? Hit the phone. What's going on, Amira? How you doing? Got him. Oh, they got his ass. So we just kind of going over the sentencing guidelines, and based on the law, what the amounts were that he defrauded, basically what he lied about making. They're using that according to the guidelines to determine the severity of the offense itself, which is rated at a level 1, level 2, 6, whatever. All right. And then the maximum time that he could get would be up to 8 years imprisonment, $250,000 for the fines, plus I think $200 for restitution. And then that can easily be increased based on the impact of any victims. Seems like so far the victim has been the government itself, the IRS. I don't know if any individual person is named as a victim. I didn't see anything. So far, the government has been the victim. The IRS is not for play. Don't play with them. They're not for play. Oh, God. He has criminal history. Oh, with regard to determining defendant's criminal history points, a criminal history category based on the facts now known to the government, defendant's criminal history points equals 0. And defendant's criminal history category is 1. Okay. He was convicted of theft, 4th degree. This is going back to on or about January 31, 2003. Defendant was convicted of theft, 4th degree, in the District Court of Johnson County, Iowa, and sentenced to 1 year of probation. Pursuant to guidelines statute 4A1.2e, defendant received 0 criminal history points for this sentence. Doesn't seem like it was a federal offense, like a misdemeanor. Theft in the 4th degree. That might be a misdemeanor. Oh, okay. I'm like, why did they give him 0? It seems like they charged it as a misdemeanor. What did he steal? This is in 2003, and he got 1 year probation. So, depending on the value of the item that he stole or whatever this theft was, it didn't even rise to the occasion of it being beyond a misdemeanor. So, probation is all he received. Probably didn't even go to jail. He may have been arrested, but he probably was not sentenced to jail. Yeah, this is so crazy. So he has the aptitude to steal things. And somehow no one looked at that and said, what's the chance that you might steal again? Y'all, Tiffany Henyard never saw this. She never looked at this and said, you know what? I don't think I want to hire a thief as my right-hand man. Yeah, you might have the ability to steal again and we not in the mood. Y'all, this man has he has stolen before. What's going on, Amir, honey? It's been a long time coming. Chris Help said the FBI spanking these arsons, still going down soon. Oh, yeah, she got it coming. June said the creditors have been victimized too. Yes, the creditors. They would be victims as well. The IRS, the creditors, bankruptcy court, child. Anybody he owed money to and he didn't want to pay, that he was ordered to pay money to. So they took him, like if he owed, any other bills or anything, loans, banks, yeah, they can all be victims and ask for restitution. Absolutely. Thank you for that. We forgot about that. Yeah, he got some creditors out here he owed money to. Oh, my good Lord. I want to know what he stole. District Court of Johnson County, Iowa. He's from Iowa. What the hell was he doing in Iowa? I thought he lived in Illinois. Oh, God. Oh, man. Oh, y'all. All right, let's scroll down here. Corporation. Let's get to this. Defendant agrees he will willfully and truthfully cooperate in any matter. Any matter. Y'all see that? In any matter in which he is called upon to cooperate by a representative of the United States Attorney's Office for the Northern District of Illinois. This cooperation shall include providing complete and truthful information in any investigation. I want to highlight this word, any investigation. Yeah. Tiffany Henyard, super. He has to cooperate fully in any investigation. Oh, this is a part of his plea deal. You understand? Cooperation is a part of that plea agreement. If not, he's facing up to 8 years in prison and $500,000 maximum in fines. Now, what's the chances of him cooperating again? Because he got 8 years in prison he's facing. Oh, Chief Freeman, you're such an idiot. Y'all, these clowns thought they would really be able to get over on this. Yeah, he tried Oh, Tiffany was probably looking for thieves. Probably. That's right. Rest in peace, Christopher Gonzalez. He had a heart attack last week, Tuesday, I think, and passed away. And they say he had just came back from his vacation. So crazy. Hit that like button, y'all. Y'all hit that like button. And share this video. Make sure you hype it up. Because we're going over this. We're not doing the whole, it's 31 pages. I'm going to give you all the link. Y'all know I enjoy doing this. It's like story time for me. But I will drop the link to the actual full plea agreement in the chat. There it is, you guys. If you all want to read the whole plea agreement in its entirety, have fun at it. But I don't want to bore you all with this because some people have ADHD and they're like, no. So that's why we're just going over and highlighting the most important parts. This corporation being one of them. Tiffany Henyard, I need you to pay attention. He must fully, truthfully, willfully cooperate in any matter in which he is called upon to cooperate by a representative of the United States Attorney's Office for the Northern District of Illinois. Oh, man. So when they call him and ask him questions about you, Tiffany Henyard, he's got to answer them willfully and truthfully. He can't get him to run around a lie. Because I think he realized in his mind, you are not worth him going to prison over for 8 years. Oh, 8 years, y'all. This corporation shall include providing complete and truthful information in any investigation and pretrial preparation and complete and truthful testimony in any criminal, civil, or administrative proceeding. So if they bring him in as a witness, he's going to have to testify. And they will. Any statements he gives to them, any exhibits that he provides, more than likely they will call on him to come in and testify to admit that evidence through his testimony into the case against Tiffany Henyard. Girl, you got it coming. Yeah, so he can't say, oh, no, I ain't coming. No. Oh, you're not coming? We'll just revoke that plea agreement. Keep playing with us. We will lock your ass up, Chief Freeman. Didn't I tell y'all he was going to take a plea deal? Oh, I said it last year. Y'all have a whole playlist, super stupid Tiffany Henyard playlist. When I went over the indictments, I said then, it was about 8-9 months ago. I said then, he will cooperate. He will flip. He will take a plea deal because he does not want to go to prison over Tiffany Henyard. Hell no. I said that. Y'all can check out the video where I said it at least twice. So here it is. He's going to have to come in and testify on any investigation regarding Tiffany Henyard, whether it be criminal, civil, or an administrative proceeding. Administrative is like when you just have the agency, like when they have those hearings from the elections board. Those are considered administrative proceedings. All right. Defendant agrees to the postponement of his sentencing until after the conclusion of his cooperation. So basically they're saying that your sentencing will be postponed because we got to know, we need assurances that you're going to cooperate. So at any time prior to his sentencing, this plea agreement can be revoked. And if they're waiting, it's because he's not the only person they're investigating. Y'all, this was just signed on and filed on March 17th of this year. About almost a month ago, about 3 weeks ago. March 17, 26. Y'all see that? This was just filed March 17th, 2026. 3 weeks ago. Today is April 12th, 2026. So they're not going to do sentencing until he has fully cooperated willfully and truthfully in any criminal, civil, or administrative proceeding, in any investigation and pretrial preparation. Tiffany Henyard, they're coming for you. And Chief Freeman will have to testify against you. So is Lacy Pillow Top Ass. Agreements relating to sentencing. At the time of sentencing, the government shall make known to the sentencing judge the extent of defendant's cooperation. If the government determines that the defendant has continued, here it is, to provide full and truthful cooperation as required by this agreement, then the government shall move the court, meaning you're going to ask the court, pursuant to guidelines statute 5K as in kite 1.1, to depart downward from the low end of the applicable guideline range. So they're going to just ask, go easy on them based on the minimum. Why, I don't know, but whatever. Defendant understands that the decision to depart from the applicable guideline range rests solely with the court. Because the judge can say, no, I'm going to go on the maximum end, the high end. Because I'm not satisfied with his cooperation. Oh, Chief Freeman, you better cooperate like hell. Y'all, they got him on a fiddle. Oh, this is awesome. This is awesome. So they'll go to court and say he did cooperate. Tiffany Henyard is being indicted. He's coming in to testify. He's done that. He has to do all of that. All of that has to be done before they move to the sentencing phase. So this could sit here for however long it takes them to go get Tiffany Henyard. If it's 6 months, this is going to sit here 6 months. Does that make sense? Oh, this is so good. What's going on, Tanya? How you doing? Oh, man. What's happening to State Johnson? Oh, June say he needs a paddle to navigate this creek. He finds himself up. I know, right? Oh, so when is the sentencing date? The sentencing will be after whatever investigations that they're conducting has been concluded and pretrial. So even if it, like, say they have Tiffany here indicted, the grand jury indicts her, and then she ends up getting a hearing. Let's say there's a trial. Even if it's a year from now, he has to do all of that first before they go to sentencing on this plea agreement. They have to have assurance that he is fully cooperating. So they leave him in limbo. He's going to be left in limbo with the sentencing until all of that is done. Whatever they're doing, that has to be completed. And then they will go to court and request that they move forward with his sentencing based on that plea agreement, based upon his cooperation. So if he failed to cooperate, he gives them a hard time, he lies to them again, he perjures himself, they're going to revoke that plea agreement. That's why they're waiting with the sentencing. So he's not going anywhere. He can't do anything because if he goes and runs, they'll just piss him off. And then they just lock his ass up and they'll take away the plea agreement. He goes to prison either way. Right? Part of that cooperation is understanding you need to be available. When we call you, when we have you come in and help with pretrial prep, when we ask you to testify, your ass need to be exactly where you need to be. Or else this will be revoked and we'll just move the court to set a jury trial for you where he'll still be found guilty because the evidence is overwhelming and he knows it. And then we'll just ask for the maximum 8 years in prison and you'll go to prison for 8 years. It's that simple. So either way, he doesn't have any wiggle room and they're going to hold his feet to the fire. Because if he doesn't, they're going to go to court and say, he's a piece of shit. He didn't want to cooperate. So we're asking that we revoke this. Yeah, no. He need to go to jail. We're not doing this. It's that simple. Y'all, this is something else. Good job. I'll tell you, I'm on the floor hollering. Y'all, y'all, he got it coming. He took this plea deal. So the sentencing should be after he is done cooperating. All right. You don't want him to be sentenced now. Oh, yeah, no. You want his ass to cooperate in its entirety with whatever they ask him to do. That's why I went over that cooperation portion. Because he doesn't have a choice. He must cooperate willfully and truthfully in any matter. Whether it be criminal, civil, or administrative, they don't care. We tell you to come in and testify, your ass is here to testify. Piss us off if you want to. 8 years in prison, heifer. Tiffany, girl. They finna throw your ass under the bus all the way there. Oh, man. Chief Freeman said, I don't want to go to prison. No, I don't want to go to jail. No. Oh, what a lying scumbag he is. All right, defendant further understands that the government reserves the right to make whatever recommendation it deems appropriate regarding the extent of any downward departure. Defendant shall be free to recommend any sentence. He can recommend it. Or his attorney will, rather. And they can be like, no. And then the judge might say, well, based on his lack of cooperation, no. Oh, this is something else. If the government does not move the court pursuant to guidelines statute 5K 1.1 to depart from the applicable guideline range as set forth above, the preceding paragraph of this agreement will be inoperative. Both parties shall be free to recommend any sentence, and the court shall impose a sentence taking into consideration the factors set forth in 18 U.S.C. statute 3553A, as well as the sentencing guidelines without any downward departure for corporations pursuant to statute 5K 1.1. Basically, they can get in there and the judge can say, listen, I don't even have to accept the guidelines that's been recommended for your sentencing. Here's what I'm going to do. It still just has to be within the confines of the law. Does that make sense? So the judge can't send him to prison for 55 years. That's beyond the standards of the sentencing guidelines itself for this particular charge. Does that make sense? Hit the phone. So it still has to be within the guidelines of the sentencing that is appropriate based on the charge itself. All right. A defendant may not withdraw his plea of guilty because the government has failed to make a motion pursuant to guidelines statute 5K 1.1. So he can't just go back and say, you know what, I want to withdraw my guilty plea because you all want me to go to prison. Hell no. Part of the plea agreement is you understanding that the judge could, within their discretionary power, say, nah, y'all asking me to give him probation for 2 years, 3 years. Okay, I'm gonna give him 1 year probation, but he got to go to prison for 2 years. He can't stand there and say, oh no, I'm gonna withdraw my guilty plea. Nope. Because he don't like it. No one cares. You better cooperate, Chief Freeman. You know I'm going to be reporting on this too. It's going to be funny. It is understood by the parties that the sentencing judge is neither a party to nor bound by this agreement because they're not. The judge is the judge. Parties are USA v. Keith Freeman. Keith Douglas Freeman? How is his middle name or last name? Keith Douglas Freeman. Oh, Lord. So the judge is not bound by either party. The judge is the judge, and they have discretionary power. Oh, shoot. What was I at? No, I don't want to lose it. All right, here we go. So they may impose a sentence up to the maximum penalties as set forth above. So that's exactly what I've been saying this whole time. The judge could use discretionary powers to say, I don't like that plea agreement. Y'all want 3 years probation. I'll give you 1 year probation, 2 years in prison. The judge can go up to 8 years and do it concurrent. If the maximum is 8 years, that's what the judge can go up to. So what they're saying is when they say downgrade, they're asking, okay, here's the bare minimum. Let's say it's 3 years probation as opposed to 3 years in prison. We're just asking for the 3 years of probation. So he's sentenced, and instead of him going to prison, he'll be on supervised probation. He'll still be treated as an inmate. He'll have to pay the fees, the community service, whatever else he needs to do. But if he violates this, then he goes to jail. The judge can come in and say, nope, I want him to go to prison for 4 years and then have 3 years of probation. Judge can do that. So that's what this means here. Defendant further acknowledges that if the court does not accept the sentencing recommendation of the parties, defendant will have no right to withdraw his guilty plea. Just because the judge says, I want you going to prison for 3 years and then you can get probation for 3 years. He can't stand there and say, nope, I'm taking back my plea agreement. Nope, that's not how that works. Defendant will have no right to withdraw his guilty plea. Just so you understand, Chief Freeman, because I know you did not understand this when you signed and agreed to this. You can't stand there and throw a tantrum if the judge decides to use their discretion, because they're not a party. They're not bound by this. The judge is not a party to this case. They're not bound by this agreement, and they could impose the maximum sentence. The maximum penalties being the 8-year imprisonment and the total of $500,000 in maximum fines. The judge could do that. You can't stand there and say, I want to withdraw my guilty plea. You don't have the right. You have no right, sir. You have no right. What's going on, Francisca? How you doing? Oh, this is too epic. June Poetry said, my bad, defrauding IRS is 6 years, 26 U.S. Code Statute 6531. Shout out to you, honey. Oh, y'all hit that like button. How you doing, y'all? Shout out to my mods. I appreciate you all for tuning in. So, yeah, he can't go back and say, oh, no, I want to take my guilty plea back. You want to send me to prison. The judge will read this portion of the agreement and say, defendant will have no right to withdraw his guilty plea. Get over it. This is crazy. This is why you don't commit federal crimes. Oh, Lord have mercy. Regarding restitution, the defendant agrees to pay restitution pursuant to Title 18, U.S. Code Sections 3663, 83, and 3664 to a U.S. Treasury, arising from the offense conduct and relevant conduct set forth above in count 2 in the amount of $281,000. So he has to pay the United States Treasury because, you know, he got refund checks from the IRS, you know, tax refunds, for $281,000. Defendant agrees to pay restitution. So he's already agreed to pay this. $281,000 to the United States Treasury. B, the Illinois Department of Revenue. That's for the state taxes, arising from the offense conduct and relevant conduct set forth above in count 2 in the amount of at least $16,578. Ooh, child. How much we looking at so far? Y'all keep up with that math. $281,000 plus $16,578. And C, the U.S. Small Business Administration, because he claimed to be a small business owner. And he got PPP loans arising from conduct set forth in the stipulated offense in the amount of $254,700. Somebody add up $281K plus $254,700 plus $16,578. What's the total on that? Anybody got the total? Can somebody give me the total on that one? Post it up when you do. This is the total amount he has to pay in restitution. $281,000 plus $16,578 plus $254,700. Damn. It does not pay to be a criminal. Yo, and that's not including if he's sentenced and he would have to pay $500,000 maximum fines. No, this is the restitution. Restitution is separate from the fines itself for you actually committing the offenses. So the maximum fines can be up to $500,000 for both counts. This is restitution. Oh, Lord have mercy. Chief Freeman, you did all of this to sit here and to cover up a Tiffany Henyard. Y'all, I'm trying to, let me get my calculator. Hold on. I want to tell y'all how much that is in total. Oh, wait a minute. Oh, 280. $280, is that 281? Hold on. 281. We got the calculator here, y'all. I had to get the calculator out. 281 plus 16,578 plus 254,700. That's $552,278. Woo! Chief Freeman, you got to pay $552,278 in restitution. In restitution. Are you going to call Tiffany Henyard and tell her to give you the money? Are you going to be calling her, telling her to give you that money? They call Tiffany Henyard and say, girl, you done got me caught up in some bullshit. Oh, you done got me caught up in some BS. I need you to send me over $552,278. You know, for all that lying and stealing I did for you. Letting you max out credit cards when we went out of town on BS nonsense. Yeah, no, I need you to send me $552,000. Y'all know she's not gonna get him out of jail. She don't care if he go to prison. So he's got to pay that between the U.S. Department of Treasury, the Illinois Department of Revenue, and the U.S. Small Business Administration. 3 whole government agencies said, we want our money back. Defendant understands that the amount of tax losses calculated by the IRS or the Illinois Department of Revenue may exceed the amount of tax due as calculated for restitution in the criminal case. So he'll still have to pay them back if the amount that they're saying for restitution is still not covering the entire amount that he said he lost. So when he lied, he said he lost $80,000. They're saying, okay, give us $16,000 in restitution. He's still going to have to pay the difference of that because he owes on back taxes. Defendant understands that the IRS will use the restitution order as a basis for civil assessment pursuant to Title 26, U.S. Code, Section 6201A4. Defendant does not have the right to challenge the amount of this restitution-based assessment. He doesn't have the right to even challenge it. You just need to pay it. Restitution shall be due immediately and paid pursuant to a schedule to be set by the court at sentencing. Defendant acknowledges that pursuant to Title 18 U.S. Code, Section 3664K, he is required to notify the court and the U.S. Attorney's Office of any material change in economic circumstances that might affect his ability to pay restitution. So if he loses his damn job, where is he working? Is Chief Freeman working? Let's just say the Doodah's novelty store gets a boom in sales. You know, he sells grass trimmers and weeders and all this other stuff. He has to report that information just as much as he would if he lost his business. So he would have to tell them, I lost my job, you know, because I'm a criminal. Oh, man. I took this FBI plea deal. It's all over the news. I lost my job. I can't afford to pay nobody. He would have to prove it because part of this is due to him filing false bankrupt and tax filings. or he lied like hell about his money. So the last thing you want to do, Keith Freeman, is tell these people you can't afford to pay them, and you're still lying to them about whether or not you can truly afford to pay it. That's the last thing your ass want to do, because they will lock you up for 8 years. Oh, this is too good. Let's scroll down. Okay. Nature of agreement. This agreement is entirely voluntary and represents the entire agreement between the U.S. Attorney and defendant regarding defendant's criminal liability in case 24 CR 191. This agreement concerns criminal liability only. Except as expressly set forth in this agreement, nothing herein shall constitute a limitation, waiver, or release by the U.S. or any of its agencies of any administrative or judicial civil claim, demand, or cause of action it may have against defendant or any other person or entity. The obligations of this agreement are limited to the U.S. Attorney's Office for the Northern District of Illinois and cannot bind any other federal, state, or local prosecuting, administrative, or regulatory authorities except as expressly set forth in this agreement. This agreement basically is saying it's limited to the U.S. Attorney's Office for the Northern District of Illinois. So if you get charged with something in the Northern District Court of Tennessee, then that's whatever agreement, whatever you have going on with them is separate from us. We have nothing to do with that. You cannot use this plea agreement to try to get away with criminal charges that another court, might convict you of. So if he go out and he steals more money in Iowa, and he gets hit with criminal charges in Iowa, that's going to be a whole separate thing. It will have nothing to do with this. Does that make sense? Defendant understands that nothing in this agreement shall limit the IRS in its collection of any taxes. That's why I said he still has back pay of taxes. They say, okay, yeah, no, you still got to pay us that restitution, but the restitution does not cover the full amount that you owe. So let's say he owed $1 million, and the restitution is for that $281,000. He still got to pay the remaining difference from $1 million. That's between $1 million minus $281,000. Just because he's ordered to pay that restitution does not mean he still does not owe the IRS more money. So whatever else is still owed, the IRS can't come for him and collect whatever else he still owes. And I'm sure it's in the thousands. Oh, man, this is something else. Y'all, this is too good. Too good. What's going on, Denise? How you doing? Tiffany should have it easy. Keep call her. I know, right? Oh, Juju, how you doing, honey? What's happening? What's happening? Y'all, they mathing on him. Oh, yeah, we had to break out the calculator on his ass. So he can still pay the IRS whatever he owes them in taxes, interest, or penalties from defendant or defendant's partnership or corporations. So if Keith Freeman LLC, his LLC owes the IRS money, then that LLC has to pay its tax penalties. He cannot tell the IRS, I'm already paying you all restitution. They're going to say, we don't care. You still owe us this money. And your corporation, your LLC owes us this money too. Pay it up. Or we can pursue charges against you on this separate amount of money you still owe. Does that make sense? Hit the vote. Hit the vote. Defendant understands the amount of tax as calculated by the IRS may exceed the amount of tax due as calculated for the criminal case. Waiver of rights. Defendant understands that by pleading guilty, he surrenders certain rights, including the following. Right to be charged by indictment. Defendant understands that he has a right to have the charges prosecuted by an indictment returned by a concurrence of 12 or more members of a grand jury consisting of not less than 16 and not more than 23 members. By signing this agreement, defendant knowingly waives his right to be prosecuted by indictment. He's waiving his right to a trial. Does that make sense? He's knowingly waiving his right to a trial by a jury. So he waives his right to be prosecuted by indictment and to assert at trial or on appeal any defects or errors arising from the superseding information. So he's waiving his right to a trial, to a jury trial, and waiving his right for any appeal. The information process or the fact that he has been prosecuted by way of information. Trial rights. Defendant has the right to persist in a plea of not guilty to the charges against him, and if he does, he would have the right to a public and speedy trial. The trial could be either a jury trial or a trial by the judge, sitting without a jury. However, in order that the trial be conducted by the judge, sitting without a jury, defendant, the government, and the judge all must agree that the trial be conducted by the judge without a jury. If the trial is a jury trial, the jury would be composed of 12 citizens from the district selected at random. Oh, man. O to B on that jury. Defendant and his attorney will participate in choosing the jury by requesting that the court remove prospective jurors for cause where actual bias or other disqualification is shown. So you can't have a biased jury. If the trial is a jury trial, the jury would be instructed that defendant is presumed innocent, that the government has the burden of proving defendant guilty beyond a reasonable doubt, which they will be able to do, and that the jury could not convict him unless, after hearing all the evidence, it was persuaded of his guilt beyond a reasonable doubt, and that it was to consider each count of the superseding information separately. The jury would have to agree unanimously as to each count before it could return a verdict of guilty or not guilty as to that count. If they do not agree unanimously, it is called a hung jury. Does that make sense? Oh, y'all, this is something else. Oh, Chief Freeman, you brought this on yourself. Let's see. Let's go down here. Waiver of appellate and collateral rights. Defendant further understands he is waiving all appellate issues that might have been available if he had exercised his right to trial. So he's waived his right to a trial, and he waives his right to an appeal. So you all can understand what's being waived. Right to be charged by indictment. Trial rights. And then right to, and I'm just going to each header, waiver of appellate and collateral rights. So defendant further understands he is waiving all appellate issues that might have been available if he had exercised his right to trial. Defendant is aware that Title 28 U.S. Code Section 1291 and Title 18 U.S. Code Section 3742 afford a defendant the right to appeal his conviction and the sentence imposed. However, he's waiving that right away by agreeing in this plea deal. All right. So let's see here. I want to scroll down some more. Pre-sentence investigation report, post-sentence supervision. Defendant understands that the U.S. Attorney's Office, in its submission to the probation office as part of the pre-sentence report and at sentencing, shall endeavor to ensure that the relevant facts and sentencing factors as applied to the facts are brought to the district court's attention fully and accurately, including facts related to the defendant's criminal conduct, related conduct, and any relevant information concerning the defendant's background, character, and conduct that the district court may consider under 18 U.S.C. Statute 3661 in imposing a sentence. So basically, when they get to the sentencing phase, whatever probation he's given, that he understands that, that has to be submitted fully and completely. If there are any issues, he needs to bring it up to the U.S. Attorney's Office, which, let's say, probation officers often attend these hearings, and they ensure that the correct probationary guidelines are being utilized when determining probation. Does that make sense? So if something happens and the probation guidelines are not being followed or adhered to, or information is not being correctly provided to ensure that he's given the correct probation, then it is the duty of his attorney to ensure that that is brought to the U.S. Attorney's Office as well as the court and the probation office. All right. More than likely, the restitution, everything that he has to pay, all the fines and fees, that will be facilitated through probation. Let's see, moving on, because the rest is fluff. Other terms, defendant agrees to cooperate with the U.S. Attorney's Office in collecting any ordered fine and restitution for which defendant is liable, including providing financial statements and supporting records as requested by the U.S. Attorney's Office. Yeah, you can't tell them you're broke as hell and you can't pay restitution. They're going to say, prove it. Lie on these documents if you want to again. They will lock you up. Regarding matters relating to the IRS, defendant agrees as follows. Nothing in this paragraph, however, precludes defendant or defendant's partnerships or corporations from asserting any legal or factual defense to taxes, interest, and penalties that may be assessed by the IRS. A defendant agrees to cooperate with the IRS in any tax examination or audit of defendant and defendant's partnerships or corporations which directly or indirectly relates to or arises out of the course of conduct that defendant has acknowledged in this agreement. So they could go back and look at Doodah's Novelty and look at this so-called online retail store and any accounts related to that, and to see if he has filed taxes and reported all of the revenue generated from this so-called Keith Freeman LLC Doodah's Novelty store. Figure out what the hell that money is going. If there's any money laundering and they come across that, they will assess that. And charges can be recommended. Yep, sure can. You can't make this up. You think he would stop committing crimes. Good grief. What was I? By transmitting to the IRS original records or copies thereof and any additional books and records that the IRS may request. So if he gets audited, he would have to still cooperate with the IRS and give them all the information they're requesting. Defendant will not object to a motion brought by the U.S. Attorney's Office for the entry of an order authorizing disclosure of documents, testimony, and related investigative materials which may constitute grand jury material, preliminary to or in connection with any judicial proceeding, pursuant to Federal Rules of Criminal Procedure and 6E3EI. In addition, defendant will not object to the government's solicitation of consent from third parties who provided records or other materials to the grand jury pursuant to grand jury subpoenas to turn those materials over to the Civil Division of the U.S. Attorney's Office or an appropriate federal or state agency for use in civil or administrative proceedings or investigations, rather than returning them to the third parties for later summons or subpoena in connection with the civil or administrative proceeding. If they say, give us the materials and provide it to us directly, he has to do it. Even if it's something related to the IRS, if the U.S. Attorney's Office files a motion to the court to say, we need Keith Freeman to surrender over these exhibits, he has to abide by the actual order. If they file that motion, the judge signs the order, he has to abide by that order. That's what this is. He can't say, no, y'all got to subpoena me for it. Nope. You give it to us because this is a part of your plea agreement. So if they want his bank statements, he can't tell them, now you need to go get a subpoena or summons for that. Nope. He's got to get his bank statements and give it to the U.S. Attorney's Office. Does that make sense? Hit the phone. All right. Let's see. Defendant understands that if convicted, a defendant who is not a U.S. citizen may be removed from the United States, denied citizenship, and denied admission to the U.S. in the future. Keith Freeman, are you illegal? They will deport your ass if you don't belong here, okay? Just saying. Conclusion. Defendant understands that this agreement will be filed with the court and will become a matter of public record and may be disclosed to any person. Defendant understands that his compliance with each part of this agreement extends throughout the period of his sentence, and failure to abide by any term of the agreement is a violation of the agreement. Yeah, violate this agreement if you want to. They will revoke this entire thing and lock your ass up. And he still waives his right to, be indicted, trial, and for an appeal. Oh, man, they got his ass on this one. Ugh. The amount of money he's going to have to pay. Oh, good grief. Defendant further understands that in the event he violates this agreement, the government at its option may move to vacate the agreement. Y'all see that? May move to vacate the agreement, rendering it null and void. My God. And thereafter prosecute defendant not subject to any of the limits set forth in this agreement, or may move to re-sentence defendant or require defendant's specific performance of this agreement. At any given time, they can say you're not exceeding or you're not living up to the expectations of this agreement. At any given time, they can look at the corporation and they can determine whether or not he is cooperating fully and truthfully. And if they determine, nah, we don't like it. Yeah. If you are lying or concealing information, if you're not cooperating with testimony or providing evidence or discovery, you go and tell them, well, y'all want my bank statements, y'all got to subpoena me for it. Nope. Nuck if you buck if you want to. That's basically what they're saying. Nuck if you buck. If you want to, we gonna buck back. And we buck back, you go to prison for 8 years. Ah, this is so awesome. Tiffany Henyard, they're not gonna take it easy on you at all. They owe you nothing. Oh man. Defendant understands and agrees that in the event that the court permits defendant to withdraw from this agreement or defendant breaches any of its terms and the government elects to void the agreement and prosecute defendant, any prosecutions that are not time barred by the applicable statute of limitations on the date of the signing of this agreement may be commenced against defendant in accordance with this paragraph, notwithstanding the expiration of the statute of limitations between the signing of this agreement and the commencement of such prosecutions. Should the judge refuse to accept defendant's plea of guilty, this agreement shall become null and void, and neither party will be bound to it. Should the judge refuse to accept, the judge could refuse to accept this plea agreement. This is what I was saying earlier. They have discretionary power. They can say, nope, don't like it, and I'm not accepting it. The judge is not a party to this case, and they're not bound by this agreement. The judge has discretionary power based on federal laws, and the judge could reject this plea agreement. They try not to, go over the state, but they could do that if they wanted to. Oh man, this is something else. What's going on, Renee Diggs? How you doing? Oh, new people coming up in here. Hey, Saint, how you doing? Shout out to my moms, y'all. Francisco up in here. Shout out to all of you all. Oh man. Serena, this is my first time listening to you, but your laughter makes me smile. It's so comforting on this lonely Sunday afternoon. Thank you for bringing me joy today. Thank you. That brings me joy. I appreciate that. Shout out to you, honey. Oh, man, y'all, we got to make these court documents fun because, otherwise they would be boring as hell and nobody will read it. You got to... Only the queen of YouTube knows how to make a FBI plea agreement fun as hell to enjoy. Oh, we got Louis Lacy's coming up today, too. We're doing both of them. Welcome to the LLC, Serena. How you doing? Welcome, welcome, welcome. Everybody speak to everybody. Make sure you guys are hitting that like button. Hit that like button. And make sure you hype the video. We're almost done. Make sure you guys hype it up. All right, let's go to, let's see. All right, so we were here at number 39. The judge could refuse to accept this defendant's plea of guilty. The judge could refuse this plea agreement and render it null and void. Defendant and his attorney acknowledged that no threats, promises, or representations have been made, nor agreements reached other than those set forth in this agreement to cause defendant to plead guilty. Defendant acknowledges that he has read this agreement and carefully reviewed each provision with his attorney. Defendant further acknowledges that he understands and voluntarily accepts each and every term and condition of this agreement. Agreed this date, March 17, 2026. Andrew S. Boutros, U.S. Attorney, Keith Douglas Freeman, Defendant, Prashant Kaluri Haley, Assistant U.S. Attorneys, Joshua G. Herman, Attorney for Defendant. That's it, y'all. He signed and dated it. Keith Freeman. It does not pay to commit crimes, you idiot. Oh, man, we have reached the end. I want to thank you all so much for tuning in and listening in to this reading, this FBI plea deal. This is something else. Shout out to Nate the lawyer. We checked out his video earlier. For those of you who came in late, please check out the replay so that you can, familiarize yourself with Keith Freeman and Louis Lacy. We will be doing Louis Lacy's FBI plea deal today as well in a separate live because, as you all can see, we're going on 2 hours, and I did not want this to be 4 hours long. So I wanted these two to be separated. And Tiffany here, you got a comment. She got a comment, girl. Oh, they're gonna get you in, girl. And they have to cooperate fully, or they risk going to prison. And I don't think Keith Freeman and Louis Lacy wants to go to prison on behalf of Tiffany Henyard. Girl, running for Fulton County Commissioner does not spare you from the FBI. They're coming for you. Oh, Lord, this is glorious. Y'all, thank y'all so much. Hope y'all enjoyed this. Keith Freeman, you got a lot of money to pay up, you moron. Over $552,000 to be exact. So I suggest you start saving your pennies so you can pay restitution. I appreciate you all. Y'all hype that button up and tune in later on. And check out the plea deal that we're going to read on Louis Lacy. And I'm going to go live on my second channel. We got the puppet video of malware. It's going to be funny, and I'm going in because this helper and made me have to file a counter. Ugh, I did not want to have to do that. But, got to do it. Got to do it. So I'm going to go in. If I got to file a counter on a fraudulent copyright strike, I'm going in on your ass. That's it. Thank y'all so much for tuning in. I appreciate you all. And to the next one. Lady Luck Club out. Deuces.